attendance is running. Please check in, all three of you. One day we'll have four again. I don't know when that be. We'll have four at some point. Okay. All right. Okay. Any questions from last class on the 13th and 14th Amendments? Tyler, were you able to watch the video?
Yes, sir.
Okay, good. And any questions, anything on your mind?
Not initially.
You sure?
Yes, sir.
Okay. All right, very good. Okay, we will continue our discussion today of the 14th Amendment with a discussion on the privileges or immunity clause of the 14th Amendment. Keep in mind that when we're talking about the 14th Amendment, that we have the privileges or immunities clause. Don't confuse it with privileges and immunities. Privileges or immunities is in the 14th Amendment, and privileges and immunities in Article 4. So just try and keep those straight. All right. Let's start with the question. I'm not going to use a poll because only 3 people here. It's easier, I think, just to raise hands. And let's start thinking about this question. The framers, the 13th, 14th, and 15th Amendments intended those provisions to protect the freedmen. One of the big debates we have in Slaughterhouse and in readings for later this week is what exactly were the Reconstruction Amendments designed to do? Were they designed simply to eliminate the state that existed before the Civil War? Were those amendments designed to rehabilitate and bring the freedmen back into our republic? Or was the broad language used designed to do something even more than that? And let's just walk through the amendments again with an eye towards this question. All right, the 13th Amendment says neither slavery nor involuntary servitude shall exist within the United States. What exactly is slavery? Right? You may think, oh, of course, slavery is simply chattel slavery, right? The ownership of one person over another. But then what's involuntary servitude, right? If you have both these phrases, slavery and involuntary servitude, the implication is they have different meanings. They're 2 different concepts. They're distinct. And then we've seen the reading today from Justice Field in the Slaughterhouse case, who suggests that prohibiting butchers from running a butcher shop is a form of slavery. Now, today you might laugh at that argument and say, that's insane, right? How could anyone, it's so insensitive to compare a health and safety law to slavery? But words don't always have the same meaning today they had 200 years ago. And maybe slavery was considered something broader. Is a segregated facility a form of slavery? If you did the readings for class on, I think, Wednesday, or maybe I think actually for next week, we have cases that say that segregated facilities might be what's called a badge of slavery or a reminder of slavery. Can Congress then take actions to eliminate not only the slavery itself, but laws in states that remind people of slavery, that bring back a state of slavery, right? So again, it was a 13th Amendment designed simply to free the slave, eliminate slavery so that the freedmen became free, or did it do something more than that? Right? Did it apply also to the ability of business owners to assert a right to run a butcher shop? And let's talk about the 14th Amendment for a minute, right? There are the 4 major provisions. All persons born and naturalized in the United States are citizens of the United States. Is this merely saying that if you were born here, you're a citizen, which means you can go to the federal court and sue diversity, basically overrule Dred Scott? Or did this provision do more than that? Did it now assert that there were some rights for citizens of the United States? In other words, you now have this group of people who are called citizens of the United States, so these people get some rights. And if so, what are these? right? What are these privileges or immunities of citizens of the United States? Are these rights that existed at the time of the founding in the 1790s? Were these rights that were popularly discussed during the 1860s? Or are these some sort of narrow rights that only affected federal citizens, right? The due process clause. The state's going to deprive a person of life, liberty, or property without due process of law. Right? First off, it doesn't say citizen, right? It's not just affecting citizens, it's persons. It doesn't say men, it doesn't say women, it said persons. And then what is liberty? Right? Is liberty merely the freedom from restraint? As the government can't lock you up in prison. Or does liberty go beyond that? Does it include perhaps a right of contract, which we'll discuss in about a week or so. Then we talk about the Equal Protection Clause. Again, it's not to men, not to women, but to persons. All right, it's a fairly broad discussion, and it requires protection of the laws. Now, what does it mean for protection? Quite literally, for the government to protect you from those who deprive you of your rights, that is, those privileges and immunities. If you read the Bill of Rights, if you read these amendments narrowly, I suppose you could say that they only sought to abolish the state of slavery and to overrule parts of Dred Scott. And that's certainly how the how the Slaughterhouse majority reads it. But if you read it a little bit more broadly, as does Justice Field, for example, maybe Justice Chase, it radically and fundamentally changed the relationship between the federal government, the states, and the individuals. Now, who's right? Who's right? We're sitting here 100 and almost 50 years. Actually, the 150th anniversary of the 14th Amendment was last year, so we're sitting here 150 years later at a huge gap in time, and we can argue about what these provisions mean. But the people sitting on the Supreme Court in Slaughterhouse were there, right? Only 5 years earlier, the people ratified this amendment. If I asked all of you what happened 5 years ago, I think we could all at least agree at a basic level on what actually happened, right? What people meant. I think at least, I don't know. But here, not even 5 years after ratification, the very people in Washington who were there can't even agree on what the damn thing means. And it's not like their disagreement's minor, right? Their disagreement is major. They see these things as so different, right? The majority says, oh yeah, the 14th Amendment, protects these little rights, these federal rights, which are no big deal. And the dissent goes, wait a minute, this would be a vain and idle enactment to put this amendment forward. It doesn't really change much. Basically, it leaves stuff the same as it was before Slaughterhouse, or before the 14th Amendment. And I guess the other side would say, well, if the framers wanted to radically change the relationship, they would have said so, right? They would have had something in the record how they want to protect all these other rights, and there really isn't much, to suggest that they want to change it. And this side, well, there are discussions about privileges or immunities, and there's discussions about Corfield v. Coryell, et cetera. If the framers couldn't, if the people in 1873 couldn't agree, how are we supposed to agree today? But then think about it. McCulloch, right, the Bank of the United States, not even a year or two after ratification, you have you have Hamilton on one side, and you have Jefferson and Madison on the other side. So we always have this problem, it seems, that even after these amendments are ratified, these constitutions are ratified, the very people who were around there and who were, alive to see this can't agree what it means. And this should give you a hope, I think, that I think reasonable people can disagree and go to very different lengths, right? But the consequence of Slaughterhouse is effectively to neuter a provision of the Constitution. It more or less read it out of the Constitution. Because after Slaughterhouse, and then you have Bradwell and then Cruikshank a couple years later, the PRI clause doesn't really do anything. It's basically a dead letter. Okay. All right. So any questions on that, on the basics background? All right, Chelsea, you're up first because Lindsay's not here. Can you please give me the facts in the Slaughterhouse cases? By the way, this was a very common idea back then that you would have lots of cases and they would just group it under like a name, like the Slaughterhouse cases or the Civil Rights cases. It confuses people. It's actually several cases. Initially, with the Obamacare case, NFIB, law professors wanted to call it the healthcare cases, but the name never stuck. Somebody wrote a book called The Healthcare Cases. They never stuck. Anyway, so Chelsea, can you give me the facts on Slaughterhouse, please?
Yes. So in 1869, Louisiana passed an act which established a privately owned slaughterhouse in New Orleans.
Good.
The act ordered the closure of all private slaughterhouses.
Good.
And every butcher in the city would have to use that single privately owned one. So the group of butchers sued the state and argued that the slaughterhouse monopoly prohibited private butcher shops and violated their privileges and immunities by infringing their constitutional right to exercise their trade or pursue a
Okay. All right, very good. So let's take a step back, right? So Louisiana passes a law that says all the butchers in New Orleans must use a single monopoly, a single private-owned slaughterhouse, right? Audrey, why did New Orleans or Louisiana enact this law?
Wasn't it because there was some like disease?
Yeah,
Happening?
sanitation issues, right?
And so they were trying to, like, their purpose was to make it all in one location.
And what's the advantage of keeping one location?
That you can sanitize and review
Right.
stuff on place.
Right.
It's easier.
Okay, so let me just give some background, right? We take advantage of the fact that today we have very stringent sanitation codes. Anyone ever work in a restaurant or a butcher, right? Okay, usually there's more people, someone's raised their hand, but the answer is yes. You've all eaten in restaurants and not the butcher shops, right? It's very stringent. You have refrigeration, right? You have, cleanliness standards, etc. In the 1860s, that wasn't really a thing. There's no refrigeration. Meat would be cut, butchered, and usually cooked very quickly. You couldn't really keep it outside. You could salt it and stuff, but you couldn't really keep it outside for very long. Also, New Orleans, today, as back then, can be very hot in the summer. And when you have meat hanging on hooks and it's hot in the summer, it leads to vermin, right? Rats, bugs, and that can lead to disease, right? People getting sick. Also, think about this part. When you slaughter a cow, for example, where do you put the blood? You put it in a pot somewhere? People throw it on the street. Yeah, I mean, where are you going to put it? You dump it on the street, or you don't. There's a lot of blood that comes out when you kill a cow, right? There's a lot of juices and stuff that flow out. So New Orleans said, okay, here's what we're going to do. We're going to make it a crime to slaughter your own animals. We're going to have to schlep all of your animals. Schlep means move. You're going to have to move all of your animals to this centralized location. And if I remember correctly, it was on the other side of the river. I can't remember exactly. I think if you ever go to New Orleans, where the big bridge, I can't remember, it was the I-10 bridge, right? Whatever it is, it's on the other side of the river. So it would be away from the population center. I think I'm right about that, but I might be wrong. I think I'm right. The idea was bring the population, bring all these animals out to this other location, so people aren't pouring blood down the in the French Quarter and on Bourbon Street, and God knows what goes on there now, but it was even worse back then. Bring all of your animals elsewhere. So, at the most basic level, right? This law was designed, at least on paper, to benefit public health and safety. Now, Tyler, let me ask you a question. Why did the New Orleans legislature grant a monopoly to this one firm? There's a real answer and a cynical answer. I'll take either one. Either one will be fine. I'll give you the other one. You give me one, I'll give you the other one.
With maybe private investors, the franchise would give more control, more incentive to run a higher class, higher
Do monopolies lower costs?
Generally not.
No. We did a case with a monopoly. What case am I thinking of? In the first week of.
Sugar?
Well, that's a good one. That's what I was thinking of. But another case with the state grants monopoly in the first week of class.
Well, was it?
Good review. Involved a boat.
Oh, the.
Right? Or not, yeah.
Involved a boat in New York.
Is it
A
there?
steamboat. No, that was
Oh,
Baltimore.
New York, New Jersey ferry.
Yeah, what was it called? See? Yeah, start thinking about these things.
That was an interstate commerce.
No, not Barron.
That one.
Not Barron.
Oh,
It's not
Gibbons.
Gibbons,
What?
right.
That one was Gibbons?
Gibbons, where New York granted monopoly to a steamboat monopoly. That only one guy's boats could enter New York Harbor waters. Right? By the way, your midterm, it's not a midterm, but when you come Thursday night, Tim will be here. He'll be proctoring the midterms. Just be ready for it. It's one of my midterms from last. I don't remember which one I gave him. It's probably better I don't tell you, but it's one of my past midterms, so you'll maybe be a little bit surprised. But please bring your notes and whatever you else want printed out. You can't have it on your computer, so just print out whatever notes you have.
Yep, that was one of the first definitions of
Commerce.
interstate commerce.
Exactly.
Which wasn't raised here.
No. This is not relevant to the Commerce Clause, but the point is New York gave monopoly to this one firm. Now, as a general matter, why would legislatures in Baton Rouge, the good folk they are, give this one firm a monopoly? That's a cynical one I'm going for. Why does any legislature give a monopoly to one firm? Oh, you guys are too pure-hearted.
Any chance they were the ones investing in it?
That's actually the non-cynical answer,
Like
but
they make money?
Would they like them?
they like them, they're friends.
Okay.
Right? It's very common for governments of all, not just Baton Rouge, right? But governments of all levels to reward their friends with political favors. It's called patronage, right? We know how that stuff works. But Tyler actually gave me the real, I think, the non-cynical reason, which is that this Slaughterhouse company fronted the money to build it, right? They basically fronted the money to build this monopoly, and on the condition that they fronted the money to build the Slaughterhouse on the condition that they would get to run it by themselves. Or in other words, they said, okay, state, we will go ahead and build this ginormous, and I have a picture in the slide. It's huge. This picture just to get the scope. It was these long rows of buildings where you basically would march in the cows on one side, see the livestock here, and then the other side you march out beef, right? So the idea was you have this huge facility, it will be clean, and it'll be away from the disease and pestilence, right? That was a fact, but let's take a step back. What was the effect of this law? It closed every butcher shop in the city of New Orleans, right? If you had a private butcher shop, you've been working there for years, maybe it was your family business, you now were out of business. Moreover, how do you slaughter your animals? You don't have to transport your livestock across town, maybe on a ferry barge, right? That's not cheap, right? Moving expensive cows from wherever your farm was to this new location, or I guess a ranch, but from wherever your ranch was to this new location is a cost. I'm sure the ferrymen loved this law because it was more money for them to ferry stuff. So let's take a step back, right? So Chelsea, if the state was really concerned about sanitation, what could they have done short of shutting down these businesses? What other kind of laws could they have enacted?
Kind of like the laws we have now. Like
Yeah.
sanitation.
Inspection.
Inspection.
Exactly, yeah, perfect. They could have inspected the businesses, and if they didn't meet certain standards, they were shut down. But instead, the state adopted a blanket rule. All the butchers were shut down at once, and they had to use this other facility without a choice. All right. Now, Audrey, the butchers challenged this law. And what was their actual legal argument? What did they assert in court?
They said that the law violated their constitutional right to exercise their trade.
Wait a minute. What the hell is a right to exercise your trade? What is that? Where would this even come from?
It wouldn't come from an enumerated right. It would be
What are unenumerated rights? Where do we get these from?
Something expressly stated in the Constitution.
Well, expressly stated would be an enumerated right.
Yes.
So what's the opposite of expressly stated?
Implied.
Very good. Implied. Right? Implied. They argue that the state law, the ban on the butcher shops, was a law that abridged the privileges or immunities of citizens. And the butchers asserted that one of these privileges and immunities was a right to exercise a trade. Right. They weren't asserting that this law violated the right to bear arms or the right to free speech. They were leading off the bat with an unenumerated rights claim. And generally, the police power of the state is unlimited, right, up to this point. But they asserted that now the state's police power to enact these health and safety laws was constrained by the PRI clause, that it involved an abridgment of their privileges or immunities. Now, Tyler, where on earth did the butchers get this crazy idea that we fought a civil war, we enacted these 14th Amendments to make sure that butchers can have their own shops, right? I mean, just taking a step back, it's kind of an insane argument if we don't know the history, right? But, we fought this bloody civil war. Blood was spilled on the battlefield, right? Slaves were wrested from their owners and put onto freedom, right? And the reason why we fought this war and ratified these amendments was so you can get our own health and safety laws and butchers can have their own shops. I mean, to say it like that, it seems kind of nuts. But where'd they get this idea from, Tyler?
That it was the what the 14th Amendment then had to decide was, are we talking about rights on a federal level or rights at the state level? And does it or does it not also apply to what my state or city of New Orleans in this case is having to do? And is it or is it not servitude to some degree?
Okay, so they did argue 13th Amendment, right? The butchers argued that forcing them to use this slaughterhouse was actually a form of slavery. I mean, Tyler, what did you first think when you read that argument?
Truthfully, I didn't understand the difference between servitude and slavery to that degree. And their perception was that the additional regulation was servitude that they are not, volunteers to.
Yeah, and I think Justice Field does a decent job of explaining this in his dissent, right? And Justice Field walks through how slavery is not just about being a chattel slave, it's actually a state of control. That's a meaning the word we don't have. We don't have the word slavery in our vernacular, in our vocabulary, to even embrace that sort of sentiment. But at least some people in the 1860s did understand slavery to be broader. But then why on earth would we fight a civil war over human slavery and then sneak in an amendment about labor regulations, right? Was that part of the intent of those who framed it? Did the word slavery have that sort of meaning that could be embraced in it? And if the people in the 1870s could not even agree on this point, how the hell are we supposed to make sense of it today, 150 odd years later? Yeah. It's a hard question. So, okay, I think Tyler's right. So first, the butchers argued that there's a violation of slavery. And second, they had said that the PRI clause at issue. Now, Chelsea, what evidence do we have to go on that the right to exercise a trade is one of the privileges and immunities of citizenship? Where do we even get that from? Where can we derive that from?
I'm not sure. I guess.
What sources of authority can we look to interpret the Civil Rights Act of '66? Damn it. I always do this. I give you the answer. I always do this. I'm so sorry. Okay, so what did the Civil Rights Act of '66 say? Damn it.
I wrote it down.
Good. Oh, I always do this. I always give the answer when I'm thinking about it.
That all persons born in the U.S. are citizens, and gave them certain rights, like to sue, be parties in the case.
And may, there it is, right? And this idea of exercising your trade is a similar concept of the right to contract. right? It's often called liberty of contract, the right to contract, or the right to pursue an occupation. The idea is the government can't stop you from earning a living, right? And that's by running your business, contracting for what business you want to run, even contracting for what wages, right? We'll do this next week, but when you impose a minimum wage, say it's $1 an hour, make it easy, unless someone says, you know what, I want to work for 95 cents an hour because I want to get a leg up, right? I can't get a job at $1 an hour, so let me try and negotiate 95 cents an hour. When there's a minimum wage, it's impossible to actually negotiate a lower wage. Now, why would you want a lower wage? It helps you get a job, hire for a lower rate. But the butchers argued that the Civil Rights Act of '66, among others, suggested that one of the fundamental rights was the right to make contracts, exercise your trade. But again, I think you're right. There's no enumeration here, right? That's not written down anywhere. We have to sort of get creative and say, well, the Civil Rights Act said this, and we have similar language here, so that must mean the same thing. But it's not a lock. Okay. Any questions so far? All right. Let's then go to the majority in Slaughterhouse. I mentioned this last class, but I'll mention it again. There was some doubt when Slaughterhouse was decided that maybe the 14th Amendment was unconstitutional, that it wasn't properly ratified. And this was the first real case that actually interpreted the 14th Amendment. Could you imagine if the court came out and said, 14th Amendment's unconstitutional, go home? So instead they gave it a very narrow interpretation, which I suppose is not good, but it's less bad than the alternative. The majority read it very narrowly. Audrey, according to the majority, what are the privileges or immunities of citizenship?
They said overall that privileges and immunities doesn't involve what Corfield said, Article 4, Section 2.
No, it doesn't.
Those rights.
What?
But it kind of limited them into just exactly what were the fundamental rights.
Okay. Tyler, what are some examples the court gives for the majority, Justice Miller, of the privileges or immunities of U.S. citizens? Give some examples. They're very strange, but it does give some examples.
Given an opportunity to even bring their case before the court.
Yeah.
Have a hearing.
Yeah, that's one of them. I'll read them to you, right? What are the privileges or immunities of citizenship? The right to come to the seat of government, to assert a claim, the right of free access to seaports, to the sub-treasuries, land offices, and the courts of justice, protection on the high seas, my favorite one from the pirates, right? And the right to use the navigable waters of the United States. Where on earth did the court get these rights from? It's not entirely clear. But what the court did is they identified some very specific rights that are associated with federal citizenship. To come to the nation's capital, navigate the federal waters, protection of the high seas. Right? In other words, the states cannot violate the rights of federal citizenship. That the U.S. Constitution was ratified, the 14th Amendment. That ratification gave new rights out, and the states cannot violate those rights. But that's it. It doesn't apply to the first 8 amendments of the Constitution. We'll see that in Cruikshank. It doesn't apply to what were deemed fundamental rights by the Civil Rights Act of '66. It's this basically made-up list of rights. So on one hand, you have two absurdities, right? The first absurdity is we fought a civil war to make sure butchers can have their own shops, right? No, that's not why we fought a civil war. But the majority is a different absurdity, right? The majority argues that we fought a war and ratified this amendment to make sure people had access to the sub-treasuries, right? We fought a war and ratified this amendment with blood on the battlefield to make sure that people could have protection in the high seas from pirates. Both those interpretations have a certain absurdity to them, but the majority here prevailed, and they were able to review it so narrowly. rather than going down the road of Corfield v. Coryell and the Civil Rights Act of '66, the court simply said we're not going to serve as a censor on legislation. The court did not want to inject the judiciary into the conflict between the states and the people. And this was a reasonable fear. At the time, we were in the midst of Reconstruction. There were lots of states who were violating the rights of their people nonstop. If now every single one of those right violation cases came to the courts would be, again, perpetual censors. And I do not think the courts want to do that. By narrowly construing the PRI clause, the justices basically said, we are not involved. Political branches, executive, president, Congress, you figure this out yourself. I am not going to do this. So in that sense, the opinion becomes a little bit more reasonable why they did it. But as a historical matter, the rights they identified are wrong. It's very difficult to find someone who defends Slaughterhouse as it's written. People might defend it that it reached the right outcome, but not as written. For example, I might say, I used to be much more critical of Slaughterhouse. I've more or less come around to the position of this, that yes, the Louisiana law violated the right of contract, but because the state needed this firm to build the slaughterhouse, the monopoly was justified. In other words, generally monopolies should not be favored, but in this case, they needed this to be built up front, and it's the only way to be built. So maybe it was a justifiable limitation, and it was not an abridgment of the rights. I don't know if I'd quite go that far, but I am tiptoeing towards it now. I think I go back and forth on things. But I think you at least say that there's a right of contract being violated, and the Louisiana law is reasonable. But the dissent went all out and said, no, that the Louisiana law is unconstitutional, and you cannot put any restrictions on this right. And I don't think I'd quite go that far. I don't know. Okay, so any questions on the majority in Slaughterhouse? Okay. Yes, Audrey.
Well, I have a question on the
Please.
dissenting.
Yeah, please.
Whenever they talk about the pre-existing fundamental rights, both dissents, or both Field and Bradley both talk about pre-existing rights, but I didn't know if that included what Corfield.
Yeah, it's the same. So the notion of pre-existing means it pre-exists government, right? That is, rights don't come from government, they come from somewhere else. They pre-exist government. And because these rights pre-exist government cannot take them away from you, right? Think of the Declaration. We hold these truths to be inalienable, that all men are created equal, that they're endowed by the Creator with certain rights.
So it's a natural one.
Yeah, natural rights. You can argue over how to characterize them, but these rights aren't granted by government, and therefore government cannot abridge those rights. And to Field, I think he would say that the natural and inalienable right that belongs to all citizens, which is a right of contract. He writes, all pursuits are open without restrictions, than such are imposed equally upon all others of the same age, sex, come back to that later, and conditions. But yeah, there was a notion that these are rights that come from somewhere else, that's not from government. And whatever laws we have merely recognize the existence of these rights. They are unenumerated rights that people have by virtue of their existence. All right, so we did Justice Field. Justice Bradley, I think, had a similar approach. He says there are certain fundamental rights which survive regulations cannot infringe. He says the government may prescribe the manner of their exercise, as how you run your business, but they cannot subvert the right itself. They cannot shut down the business altogether. In other words, the reason given must be the actual reason. They can't have a pretext, say, oh, we'll shut down your business for health and safety, when it's really to give their buddies, a monopoly. I don't think that was the case here. Okay. All right, so questions on Slaughterhouse. All right, today almost everyone agrees that Slaughterhouse was wrong. Almost everyone. Not everyone, but just about everyone. But the Supreme Court has not shown any willingness to reconsider it. Indeed, in an opinion yesterday, which I spent 90 pages reading, Justice Thomas faulted the majority for not overruling Slaughterhouse many, many years later. So he's still complaining about this point. He's right. I think he's right, at least. All right. Any other questions on Slaughterhouse? Please, Chelsea.
Do you think that they could have had or brought it up under any other part of the
Oh, what a good question, right? Why didn't the butchers assert a violation of the due process clause, right? Why didn't the butchers assert a violation of the equal protection clause? Slaughterhouse gets at this a little bit, but the short answer is probably, and this gets a little more controversial, the law was enacted through the proper procedures. It was a duly enacted law, right? They were not being deprived of their property. The law only regulated where they could slaughter their animals. So I think the argument was it wasn't relevant, right? Why is a due process clause, a provision about process, relevant when they're depriving you of your rights? Today, of course it's relevant. Back then, I don't think it was so obvious.
Like everything nowadays is under the due process.
Oh, it does, my friend. We will go through that at some length. And then equal protection, right? The law applied to all butchers equally, right? All butchers were subject to the same regime. It wasn't that, some butchers go here and some butchers go there. All the butchers in the town went to the same location. So the law is being enforced equally, right? The only provision that made sense for them was the Privileges or Immunities Clause, because that was protection of legislation that violated their rights. Think of the next case, right, with Myra Bradwell. In that case, the law was not being enforced equally. Men were allowed to go to the bar, and women were not allowed to enter the bar. Why didn't Myra Bradwell put all of her eggs in the equal protection basket? Because at the time, the clause people thought of was PRI. That's the clause you bring it under. And the court didn't really even address these other provisions at all. But it's a good question, Chelsea. I've often thought about that myself, right? If you're a lawyer, you put the kitchen sink, right? You throw everything at them, hope something sticks. But here, they focused on what they thought would be the best argument. Do you have any other questions on Slaughterhouse?
Why was interstate commerce not brought up? I mean, why wasn't?
Why would it?
Commerce
But this is a state legislation, not federal.
If government had already, if there was precedent that state law cannot create monopoly in Gibbons.
Well, the issue in Gibbons, recall, was that the state monopoly conflicted with a federal law concerning interstate movement of boats. Right? I don't think there's any federal law that would have a conflict here. Right? The problem in Gibbons wasn't the monopoly. The problem in Gibbons was that the monopoly conflicted with the federal law. Right? And that was a violation of Congress's powers, preemption over commerce. I don't see any federal law that might be a conflict here, because generally inspection laws were reserved to the states. Does that clear up your question a little bit?
It does.
Okay, good. All right, so any other questions on Slaughterhouse? All right, let's move on. I think, Audrey, you're next. Let's do Bradwell. Okay, so, and Bradwell was decided the day after Slaughterhouse. So poor Myra Bradwell. Can you imagine if, there was no computers. I doubt she even knew about the case right away, but, let's say in the offhand chance she learned about Slaughterhouse, and the court basically said, we're not going to give anything in PRI. Audrey, what do you think Myra Bradwell would have wanted to do after she realized that Slaughterhouse was decided? What would you do if you were a lawyer, right? And there's a case that's already decided that impacts your case.
Bring it under another claim.
You come back to court and you re-argue a different way. You say due process or something else. She didn't get the chance because they did it one day later, right? She did not get that chance. All right, so Audrey, give me the facts in Bradwell, please.
So she was a aspiring attorney. She's
Yeah.
a woman.
Uh-huh.
But she.
Did she go to law school?
Yeah, she met all of the.
No, did she go to law school?
Oh no.
How did she get her legal training?
I think she practiced in Illinois for.
How did a person become it's not the reading.
A certificate.
How would a person become an attorney before law schools became a popular thing?
Don't they have to do like an apprenticeship?
Very good. Who is she an apprentice for?
The newspaper.
Well, that's where she works as a reporter with her husband. Her husband was a lawyer. Yeah, her husband was the attorney. And she served as an apprentice for him. And that's generally how you became an attorney. You would serve as an apprentice for some time. And then you could be admitted to the bar of the state by either taking an exam or the court would admit you. Right? There wasn't really an exam the way we think of it today, but there was like there were ways they could test you.
So she
So-
worked as an apprentice
Yeah.
under her husband.
Good, yeah.
And so that required her to meet all the prerequisites and character.
Not necessarily. I actually don't know what the requirements were, but she did work as an apprentice under her husband. And then she sought admission to the bar.
Mm-hmm.
Why did the bar deny her admission? There's actually a fairly important reason that the Illinois Supreme Court relied on.
I guess I don't have it written. But the
Well, let me ask you a
state
question.
of Illinois, their Supreme Court, why they denied it?
Yeah, why they deny her entry to the bar?
I mean, I'm just gonna guess because of her kingdom.
But specifically. Tyler, do you know?
Contract issue, right? She was married, she couldn't enter a contract.
Yeah, this bingo. Okay, so you'll learn this in property. Do this in property? Okay, so in property, you'll say what's called the law of coverture. And coverture was basically it's a French word, couvert, right? Whatever. But it referred to covering, right? That when a woman was single, she had various property rights. But when a woman got married, she basically ceased to exist. At that point, a new legal fiction was created, that it was the husband and wife together, which the husband then administered. So the husband had complete control of whatever finances the wife had during the marriage. If there was a divorce, or if the husband died, the widow, the woman would regain her property rights. But during the pregnancy, during the marriage, the woman's basically incompetent to do anything. And I don't mean incompetent in the sense of stupid, I mean incompetent in the sense she's like a minor, right? She lacks the capacity to make a contract. She lacks the capacity to take out a sale of land, right? She can't. Her husband would have to authorize any sale. So under the laws of Illinois, could a married woman have even entered into an attorney-client relationship, which involves making various contracts? I don't know the answer to that question, and the Illinois Supreme Court said, no, she cannot. So it's even possible that the denial of her rights, even if there was a right to an occupation, it's possible that because of the laws of coverture, there was a reasonable justification to deny her that admission, right? Even if Justice Chase was correct in dissent that there's a right at issue, maybe the state had a reasonable justification for it, similar to the monopoly law. But the court doesn't need to go down that road. The majority opinion in Bradwell is really easy, right? Chelsea, why is the majority opinion in Bradwell so straightforward and simple?
He basically says that they just did Slaughterhouse and they're not going to go
Yeah.
back into
Yeah.
something that's
Yeah, they just decided Slaughterhouse the day before, right? Obviously, these opinions were written in advance, but they decided Slaughterhouse the day before. And all the majority had to say, Justice Miller, is the 14th Amendment doesn't protect the right of contract. It protects federal rights. Serving as an attorney in the Bar of Illinois is not a federal right. It has no connection to U.S. citizenship, right? As a result, no right was abridged. Easy. Right? If the butchers aren't covered, then the right to serve as an attorney is also not covered. It in no sense depends on the citizenship of the United States. That's easy. Yeah, that's straightforward. But as you recall, there were dissents. There were 4 dissenting votes in Slaughterhouse. Field, Bradley, and Swain. There's also Chase, but we'll get back to Chase in a minute. Field, Bradley, and Swain had a little bit of a more difficult challenge because they had to thread this needle. On the one hand, the butchers, who were men, had a right to pursue their field, which was butchery. Butchery? What do you call it? Butching? What else do you call it? The field of slaughtering? I don't know. Butcher, whatever. On the other hand, you had Bradwell, a lawyer, or a female attorney, that you have the right to practice your trade. Justice Bradley wrote an opinion that always makes students wince every semester when I teach it. And he had to go out of his way to explain why is it that men are allowed to pursue an occupation, but women are not. And he goes all in. He basically explains that women are an inferior sex, and the law has always respected a difference in the spheres of men and women, that women are unfit for the occupancy of civil life. And under the laws of coverture, the woman has no separate identity and cannot make contracts. In other words, women exist to be wives and moms of children. That's it. That's what the law of nature dictates. Now, if states want to afford additional protections to women, they can do that. But that's at the discretion of the democratic process. It's in no sense compelled by the federal Constitution. In other words, the federal Constitution did not change the fact that all states had coverture laws. Right? I mean, think of the other way. If the rule is otherwise, then basically the coverture laws in all 50 states would be unconstitutional. Well, there weren't 50 states, but the coverture laws in all the states would be unconstitutional. Was a civil war fought and these amendments ratified to basically overturn the entire property regime nationwide? Well, that's the question. What was the intent behind those who framed the 14th Amendment? Or does their intent even matter, right? Again, the language is broad. It says, no state shall make or enforce a law that abridges the privileges and immunities of citizens, not of men, not of women. Right, there was a famous story, I think it was Susan B. Anthony, the suffragist, who basically walked into a polling place and said, I want to vote. And they said, we can't, the law doesn't allow it. She said, well, but look at the Constitution. It says person, right? It doesn't say men. And she got a ballot, which was then thrown out later. The language is a hell of a lot broader, right? And what does that mean when you have these broad words with a narrow intent, right? That the people who drafted it maybe had a very specific focus, but they used very broad language. That then allows later generations potentially to read more into the provisions than was already there. And you go from a case like Slaughterhouse, where you can look at the Civil Rights Act of '66, to cases later involving gay marriage and sodomy and abortion, where they use these same words and read into it concepts that would have been unheard of in the 1860s, right? How far can you go from the meaning of these words, right? How far can you take them when the meaning perhaps isn't completely specified in the text? Okay. So any questions on the Bradwell majority or Bradwell dissents? Okay. No? All right. Then we have Chief Justice Chase, right? Unfortunately, we have no opinion from Chase. He was very ill at this time. I think he died a few weeks after Bradwell was decided. He had a stroke that took his life. But Chief Justice Chase dissented in both Slaughterhouse and in Bradwell. And he didn't write an opinion because he was quite ill, but he noted in his opinion, or in the record, that he dissented not only from the majority opinion, he also dissented from the concurrence, because he wanted to stick it to Justice Bradley, who wrote the notorious concurrence. And Chase, for what it's worth, I know Randy loves him, but I think he's a good guy too, had fairly progressive views on race and gender equality, far ahead of his time. And he had some positive things to say about women in his employment. He said, I've always favored the enlargement of the sphere of women's work and the payment of just compensation for it. But he wasn't able to write anything in Slaughterhouse or Bradwell, and he simply noted his dissent. Okay. All right, questions on Bradwell or Slaughterhouse? Okay. The last class today is Cruikshank. Okay, Cruikshank. In some regards, the cases seem out of order, right? If we have this new provision of the Constitution, and we want to bring a case to court to discuss what it means, you usually start with the easier case. What's easier to argue? That the word privileges or immunities means the right of contract, which appears nowhere in the Constitution, or that the phrase privileges or immunities means the Bill of Rights, the first 8 amendments. I think that you're a hell of a lot better going off with an enumerated right, First Amendment, Second Amendment, than an unenumerated right. Because at least it's written down. There's no debate about what it means. But for the most part, Slaughterhouse closed the door on unenumerated rights, like the right of contract. The next case, Cruikshank, closed the door on enumerated rights. That is, the right listed in the First and Second Amendment. And this case arose in a gruesome fact pattern. Who's that? Tyler, you next, I think?
Yes, sir.
All right, you want to run me through the facts, please, in Cruikshank?
So, Colfax, Louisiana, I guess it was the parish seat, or equivalent to a county seat.
Exactly.
The numbers were 400 of these African American militiamen that were armed with their weapons remaining from their role in the Civil War. They took over this courthouse, and approximately 150 white opponents proceeded to engage with them in combat to remove them. They were unsuccessful with their weapons, and they proceeded to light fire in order to smoke them out into the courthouse. Now, when they came out and surrendered, they weren't just captured and arrested or anything, as they were killed upon sight. I think the actual charges were conspiracy. The government issued nearly 100 indictments, to individuals for conspiracy, but only captured a few and served a few of them. One of which was Cruikshank. So the debate was, and I think Cruikshank's attorney was a former Supreme Court justice, and their argument was on, the first peacefully assemble, and second bearing arms, those enumerated rights within the Bill of Rights. Did they extend to the individuals, or once again, was it just specifically talking about states' encroachment upon those rights by the federal government?
Yeah, very good. Thank you so much for that. We have a situation, right? We start with Barron. In Barron v. Baltimore, Chief Justice Marshall said that the first 8 amendments only limit federal power. And that was the rule for almost 100 years. Then we get to the debates over the 14th Amendment. And many members of the Senate and the House who voted on the 14th Amendment seem to think that this provision would now protect the states, right? That now the states would have more limitations in their power. Specifically, the states cannot deprive people of the right to bear arms, the right to free speech, and the right to peaceably assemble. Right? There's a lot of evidence that this is what was understood to be privileges and immunities, right? That these rights are so fundamental. Even Chief Justice Taney and Dred Scott suggested the right to bear arms was a privilege and immunity of citizenship. As a result, we have the Cruikshank case. Now, generally, right, if 100 members of your community massacred an entire population, you would think that the local sheriff would arrest them and the local district attorney would prosecute them in state court, right? You would think. That didn't happen here, right? The local Louisiana government, always Louisiana, I guess, a lot of Louisiana cases, the local Louisiana government was fine with this. They probably supported the lynchers. As a result, the state government took no action to protect their rights. They were slaughtered in cold blood. Gruesome, gruesome massacre. Instead, the federal government stepped in. And the federal government decided to prosecute and charge these individuals. Now, the key point here is that Cruikshank and others were actually acting under the color of state law, right? They weren't just private citizens, they had some state authority. The 14th Amendment allows the federal government to take action to prohibit state actors who violate rights. And the argument was that Cruikshank engaged in a conspiracy to deprive the freedmen of their right to peacefully assemble in the courthouse and their right to bear arms. Now, Chelsea, why didn't the feds just indict Cruikshank with murder? Why do they have to do these sort of creative arguments about bearing arms and peaceful? They killed him. They burned him alive. They killed him. Why can't they just charge them with murder? Simple, easy. Charge them with murder. You're done. Why do they have to work in this PRI stuff?
During this time period, did they have federal?
No, they did not. The entire idea of a federal murder was limited to, like, if you were in the District of Columbia, maybe, or maybe you were on a military base, or maybe you were in a federal territory. But at the time, a murder committed in a state was a murder. I mean, even today, what the hell is a federal murder? Right? If your bullet crosses a state line, maybe? Right? If you, there are some easy ones. If you kill a member of Congress, for example, or if you injure someone in a federal proceeding. But even today, it's unclear exactly what a federal murder is. Think of, for example, the Boston Marathon bombing, right? This happened a couple of years ago. They were basically being charged on using destructive devices that travel in interstate commerce, right? The crime is not actually the fact they committed the murder here, but they tried to kill people, or they did kill people, with a device that traveled in interstate commerce. So you still need a jurisdictional hook for the Commerce Clause. That didn't exist in the 1870s. So they had to try them, basically, not with murder, but for depriving the rights of the freedmen, depriving the rights of the First and Second Amendment. Right? Audrey, what did the court do? Justice Waite for the majority. Chief Justice Waite.
He found that the states were still not bound by the Bill of Rights or the First State Amendments.
Yeah.
Even after, before and after the 14th Amendment.
Yeah. In other words, Barron was still correct. Barron was still correct. That basically the 14th Amendment didn't disturb Barron. And therefore the states are free to deprive people of their rights. Tyler, the last point I want to stress is, even if the 14th Amendment's not violated, what about the Civil Rights Act of '66? Didn't it prevent state officials from depriving people of their rights based on their race? Even if we don't have the First and Second Amendment, doesn't this law prevent people from being killed because of their race? What did the court say about this?
And I don't think that was, I think the Justice Waite relied on the 6th and went with a procedural argument, and that their indictment didn't specifically focus on that point.
Yeah. Can you imagine? What the court basically said is there's nothing alleged in the record to suggest that these actions are taken based on their race. Give me a freaking break, right? I mean, it's hard to look at this massacre where these people burned alive and then shot and dragged down to the river. Right? It's hard to look at this massacre and say, oh, that's not because of race. But here the court gutted the Civil Rights Act. They gutted the Privileges or Immunities Clause. So the upshot is, after the Civil War, and with the ratification of the 13th and 14th Amendments, what actually changed? Well, at the most basic level, slavery, that is, chattel slavery, was abolished. But the federal courts would not intervene to protect the enforcement of rights. And the states could enact these discriminatory black codes and indeed have their own people murdered by the hundreds and take no action in response. What you're seeing today in both Cruikshank, Bradwell, and Slaughterhouse is the court's early efforts to neuter the 14th Amendment. And these cases are still good law. In 2010, we have a case called McDonald v. Chicago. And the question is whether the city of Chicago can ban handguns in the home. 4 justices, Alito, Roberts, Scalia, and Kennedy, held that the right to bear arms is a liberty protected by the 14th Amendment's Due Process Clause. Therefore, the states cannot deprive people of their right to keep a gun in the home. And Justice Thomas wrote a very long opinion, it's in your book, you can read it, explaining that the right to bear arms is a privilege or immunity of citizenship, that Cruikshank was wrong, that Slaughterhouse was wrong, and the court should reconsider it. How many justices were willing to overrule Slaughterhouse? 0. None. Only, I'm sorry, other than Thomas. Only Thomas. There's only 1. And I think that continues to this day. Okay, questions? Yeah, Chelsea?
Okay, and I'm sorry in advance.
Don't apologize. You do not have to apologize for asking a question. Never.
So, I guess I'm a little confused because I didn't, like, in Dred Scott we talked about, like, a state citizenship or
Yeah.
a natural citizenship, and it was determined that even if a state gave you that, there was no bearing, but now they're going back, like, there's different rights between.
Well, okay, so now you're a citizen, right? And what the court says is because you're a citizen, you now get certain rights as a U.S. citizen. But there are no additional rights given to you for being a state citizen. In other words, let me reformulate Chelsea's question. In Dred Scott, Tawney drew this distinction between state citizenship and national citizenship, right? And Tawney said that if you were a natural citizen, you would then get the privileges and immunities, right? So you still get those. But the problem was the states enacted black codes. They treated their own blacks in a discriminatory fashion. So therefore, a black from another state would get the same sort of discriminatory treatment. All Article 4 says is you treat your own people like you treat people from other states. And that's still the rule. But here, Louisiana said we don't give these rights to any black people. It makes it a lot easier. But yeah, there's a very strange overlap between the Tawney opinion and the Dred and Slaughterhouse. So they draw a distinction between federal rights and state rights. One note: yesterday I criticized Justice Gorsuch a bit. He wrote an opinion that he was talking about stare decisis, and he said, if we still had stare decisis, we might still be following Dred Scott. And he knows better. He was trying to make a point. But Dred Scott was never overruled. It was the 13th, 14th, and 15th Amendments that killed the case. So anyway, I was annoyed that Gorsuch. He knows better. He's smarter than that. He was trying to make. He was like, if it was still for stare decisis, we'd be following, Korematsu and Plessy and Dred Scott. So we know. I replied. I didn't reply to him, but I tweeted that basically Dred Scott was not overruled by a case, and Korematsu is only overruled in the court of history, wherever the hell that is. I don't know where that is. I mean, address. Plessy was kind of overruled, but not really in Brown. We'll get to that later. Okay. So any questions on the 3 cases for today? All right, tomorrow we'll be doing another 3 very important cases. We're doing the civil rights cases, Yick-Wo, and Plessy. The civil rights cases concerns whether Congress has the power to prohibit segregation in places of public accommodation. And in this case, the court basically kills the Section 5 powers. In the second case, Yick-Wo v. Hopkins, you have a situation where the city of San Francisco denies permits to Chinese launderers, but not to everyone else. Everyone else gets a permit. The question is whether this deprives them of their liberty of contract. It's often viewed as an equal protection case. I don't think it is, but we'll get there tomorrow. And the third case was a notorious Plessy versus Ferguson, in which the court upholds a separate but equal doctrine with respect to the Equal Protection Clause. As long as you have separate accommodations, it's fine. Man, with 3 people it goes even quicker. There are no questions. All right. I could teach this class probably in like 13 classes if I knew it was this small. I would just compress it. Anyway, I can't do that. Anything else? No? All right, I'll see you all tomorrow. Have a good night. And again, midterm on Thursday, no class. I won't be here, but the midterm will be on Thursday.